Good afternoon, everyone. Thank you for joining us for today's webinar on harassment at work. I know some people are still coming on, so I'll just very slowly introduce myself so that we'll give folks a chance to keep logging on. But we do want to get started as we have a jam-packed hour ahead of us. So my name is Jessica Steingard, and I am one of the staff lawyers here at the Center for Public Legal Education, Alberta, and I'll be facilitating today's session. Behind the CPLEA logo on your screen, you might see, you'll see a little box there. Natalie Tremblay is our Educational Design and Evaluation Specialist. She'll be managing the chat today. So as you see things pop up, that's Natalie, putting links in there for you and whatnot. And if you have any questions, any procedural questions, I should say throughout today's presentation, please pop them in there. But we will also leave time for questions at the end of the presentation, and you are welcome to throw your questions throughout into the Q&A function on your screen. We will probably just leave them till the end, but if they pop up during the presentation, you're welcome to throw them in there so you don't forget them. Okay, before we move on, I'd like to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those this great land today. So I am in Treaty 6, but we know that people are joining us from across the province and even beyond. So welcome. And this wouldn't be a presentation about legal information if we didn't have a little disclaimer in here. So just a quick note that today's presentation contains legal information only, and it is not intended to be legal advice. I would also like to acknowledge the generous funding we receive from the Alberta Law Foundation and the Department of Justice Canada, which make presentations like this one possible for us to put on. A few other housekeeping items. We will be posting a recording of the webinar on our YouTube channel. So I will send out a message through Eventbrite when that has gone up, probably about a couple weeks. So you'll be able to go back and watch it afterwards as well. As I already mentioned, we ask that you save your questions till the end, but you're welcome to use the Q&A box throughout to drop your questions in there, and then we'll leave some time at the end to go through those questions. And finally, when you leave today, you'll be prompted to complete a short survey letting us know how we did and any other topics you might be interested in. So we'd really appreciate if you could take just 30 seconds and fill that out for us so that we can keep putting on great webinars. So I mentioned that we are the Center for Public Legal Education Alberta, or CPLEA for short. And what do? Well, our goal is quite simple, and that is to make the law understandable for Albertans. So we are a nonprofit organization that and we serve all of Alberta. We provide legal information and education through various booklets, info sheets, videos, FAQs, websites, articles, and more. All of our information is free and available online. Our goal is to make the law available and understandable so that Albertans are empowered to use it. As I said, all of our information is available online for free. So this is our website, cplea.ca, and you can see the variety of topics that we cover, and you can find lots of great information there. Okay, so really the meat of today's presentation is going to be a panel discussion with my esteemed colleagues here. So you'll see a few other faces on your screen, and I'd love to introduce them to you right now. So we'll start with Evan Oikawa. Evan is an employment and human rights lawyer practicing at Osuji Smith Lawyers, which is a fast-growing law firm in Calgary with a strong reputation in employment law matters. His practice focuses on employee side cases and helping individuals advocate for their rights. Welcome, Evan. Next is Andrew Skeith. And Andrew is an associate lawyer at the firm Reynolds, Mirth, Richards, and Farmer. He practices primarily in the areas of labor and employment law, municipal law, and defamation law. Welcome, Andrew. And our third panelist this morning is Quinn Blythe. And Quinn is the sexual harassment legal specialist at the Workers Resource Center And we'll be sharing a little bit more about what the Workers Resource Center does later in our discussion. So welcome, Quinn. So we have a few questions that we would like to go through this morning in a little bit of a discussion style. And I thank you for those of you who submitted your questions to us. We hope to cover most of them in today's presentation. So thanks again for sending those in. So let's get started with question number 1. So what is harassment and what's the big deal about it? So I'm going to turn it over to Evan to kick us off with this first question.
Hi, Jess. So I just wanted to say thanks so much for having me. I appreciate it. I think this is an important topic to talk about, so I'm excited to participate. So what is harassment? So in Alberta, there is legislation, occupational health and safety legislation, that's basically designed to regulate the workplaces in Alberta and to provide safe and healthy workplaces. So that legislation defines what harassment is, and it contains a quite broad definition. So basically what the definition is any single or repeated incident of objectionable or unwelcome conduct, comment, bullying, or action intended to offend, degrade, or humiliate a person or group. So this can include a wide range of different types of behavior. So it can include, unprofessional or abusive text messages and emails, insults, demeaning language, swearing. It can include spreading rumors or gossip or excluding someone. It can also include deliberately misgendering someone, as well as a situation where, say, a supervisor sets up someone to fail. So providing, unreasonable demands or setting impossible deadlines. So those are all different examples of harassment. It can also include any type of action that's discriminatory. So discrimination based on things like race or gender are big ones. And the OH&S legislation also has a definition of what harassment isn't. And harassment isn't cases where management is reasonably, exercising its management rights. So things like minor personal conflicts or constructive feedback typically wouldn't rise to the level of harassment. So that's kind of what the legislation in Alberta says about harassment and how it's defined. And why is it a big deal? Well, it's a pretty serious issue because harassment in the workplace can cause like psychological harm to employees. And that's why the legislation case law has developed to provide protection to employees and basically give them the right to work in a civil, respectful workplace environment. From an employer's perspective, harassment can have a big impact on productivity, profitability, as well as exposing the employer to potentially to legal liability. So I think it's a very important issue for both employees and employers to, consider and talk about.
Excellent. Andrew, did you want to add to that?
Thanks, Jess. Yeah, Evan did a great job there, really laying out just how broad harassment really is. And the only thing I would add is that there's a recent case, which I might talk a little bit about, which created a tort of harassment. And the judge in that case, when trying to define what harassment is, he said that it's impossible to define it in any given situation. It's more determined based on a case-by-case basis. We know it when we see it. And I think that's pretty accurate because other than just OH&S and human rights and constructive dismissal, you have a harassment in a wide range of contexts. So all of those, but even things like, you can get a restraining order for harassing conduct, and this tort of harassment take place at work and in a related to the workplace. So it is a very, very broad concept. And yeah, I don't have anything to add as to why it's a big deal.
Perfect. Thank you. Quinn?
Yeah, so that was great summary by Evan and Andrew. I'll start by saying that I'm the non-lawyer here. I am a social worker. And so I work with people who experience specifically sexual harassment and other types of gender discrimination. So the only thing I would add when it comes to, and so I'll speak specifically to that, it can be direct or indirect. So some examples of some indirect sexual harassment can be visual displays of suggestive sexual images and things like that. It also is quite broad, but I think Evan did a good job at summarizing that.
Perfect. Well, hopefully that gives our viewers an understanding of how broad the concept of harassment can be. And also we've touched on some of the different legal areas in which harassment comes into play. And I think that leads us really nicely into our next question, is what does the law say about harassment at work? And I know Evan's already touched on the occupational health and safety bit a bit, but Andrew, is there any other laws that you'd like to highlight when it comes to harassment at work?
Sure. Yeah. I mean, there's many different. Evan mentioned sources of liability for employers. There's lots of different contexts. One of the most obvious ones, well, it might not be obvious to a lot of people, but there's something called constructive dismissal. Are familiar with this idea, they can be fired or let go from their jobs with or without cause. They usually imagine a scenario where their employer just sits them down and tells them, you're done here for whatever reason. But there's this other more nebulous concept known as constructive dismissal. And really what that means is, if the employer acts in a way that they no longer intend to be bound by the employment contract, the employee can consider themselves as having been factually terminated. And for our purposes, one of the ways that can happen is when the employer either allows a toxic workplace to be created and persist, or creates one. So whether the harassment comes from management or just from other employees and management lets it happen. At a certain point, employees are not required or expected to continue to work in a toxic and intolerable work environment. And that at that point, the law says, well, the employer has actually terminated you and you're entitled to the remedies you get when you're fired. So reasonable notice or pay them. So that's a really big source of liability. The other one related to that is human rights, the human rights context. So when someone in the workplace is subjected to harassment and it's related to a protected ground under the Alberta Human Rights Act, and a protected ground is something like race, gender, sexuality, family status, mental or physical disability, religion, all sorts of things. Harassed at work in relation to any of those grounds, you have the right under that piece of legislation to submit a complaint to the Human Rights Commission. And, it can name your employer, especially if you're being harassed. That's the most typical kind of circumstance. It can also name other employees. And you can get a whole variety of different remedies through that context. So it's important, obviously, for employers to be mindful for a lot of reasons, but those are just a couple of reasons why you'd want to be careful of ensuring that harassment is dealt with properly in the workplace. And the other one I touched on earlier was this new tort of harassment. It's never been tested aside from this brand new case, but it's really interesting. And it's basically where somebody engages in repeated communications or threats, insults, stalking, or other harassing behavior that they knew or ought to have known was unwelcome, which impugn the dignity of the plaintiff or cause a reasonable person to fear for his or her safety, or could foreseeably cause emotional distress and caused harm. And so if an employee is being harassed in the workplace, they could sue the person, theoretically, who was harassing them under this new tort of harassment. And through this principle of vicarious liability, which means basically the employer could also be sued in that situation. The employer could be liable at common law for monetary damages. So those are a few of the main areas, but I know Evan to talk about those.
Yeah, I think Andrew did a really good summary of sort of the main issues of liability, the main types of claims that an employee could raise in the context of harassment. One of the things I think might be worth adding in the context of a discrimination claim for human rights is, typically in a wrongful dismissal or constructive dismissal claim, you're looking at the most you could receive in damages for lost wages in Alberta would typically be about 2 years. But if the claim is made under human rights, the Human Rights Tribunal isn't necessarily limited to sort of the common law assessment of damages. So it's possible that lost wages could be awarded for a lengthier period. As well, typically under human rights legislation, we see awards of what's called general damages being made. And these are basically meant to compensate an employee for sort of the injury to dignity as a result of the discrimination or the harassment. And these types of damages have been trending upwards in Alberta in recent years. So we've seen in a recent case related to sexual harassment, there was an award of general damages of $50,000, which is, I believe it's, and Andrew might be able to correct me if I'm wrong, but I believe that's the highest that's been awarded in Alberta to date. So there may be certain advantages to filing a complaint through human rights if the facts of the situation show that there's been discrimination and it's related to a protected ground such as race or gender or something along those lines.
Perfect. Well, thank you both for that great summary. And so if I may just kind of summarize what I heard as well, in terms of different laws that speak of harassment at work, we've talked extensively about human rights. And so there's the Alberta Human Rights Act, which goes into more detail about what that covers and those protected grounds that they mentioned. We've also covered it in the occupational health and safety context. So again, there's the OHS Act and code and regulations associated with that. And then we've talked about it also from the civil law perspective or the common law perspective, where we have this tort of harassment as well as constructive dismissal. So those exist in what we call common law, as Andrew said, or this judge-made law. So there's no written law about it, but it exists in this judge-made context. So does that cover everything? Is that from Andrew and Evan? Did I miss anything?
Yep, no, that's good.
Just as a little overview, a little takeaway from that question, and to keep that in mind, because these themes will continue to come up through the other questions. So hopefully we've kind of laid a foundation for those of you watching to kind of understand where these different sources of law are. Okay, so as we talked about, what does the law say about harassment? Now moving into the different players that might be involved when we speak about harassment, including those experiencing it, those witnessing it, and an employer. So let's start this next question of what can someone do if they have experienced harassment at work? And I'm gonna start this one with Quinn.
Yeah, so this is a really important question. I just want to start by saying that it's really important to remember that nobody asks to be harassed at work. No blame lies with the survivor. And people respond in a variety of ways. So they may freeze, they may situation, may confront the person, or they may just go along with it. A lot of us work because we like our jobs, but we also have bills to pay and families to care for, and people worry that if they report it, that they'll get terminated or punished for doing so. So a lot of people don't go that route. So it's important to remember that there's no right answer, People do what they need to do to stay safe. But if you are experiencing harassment, you can confront the person if you feel safe to do so. Like I said, often people don't. You can also report it to someone in charge, such as a manager, someone in human resources. It's also important to gather evidence. Now, in my experience, people that harass others are good at it. So they don't usually put it in writing. They're not sending people emails and texts that have harassing and discriminatory language, because they know that, that's, they can have that used against them. So if somebody is harassing you verbally, in person, you can make notes to yourself, keep things in a journal, the dates and times that it happened, so that if you do choose to go forward with a complaint in the future, you have information, the details of it, as you'll need that. You can also make a formal complaint to human rights, which we've talked about. That's something that I assist clients with that I think I'll talk to more at the end. So yeah, just important to remember that there's no right answer, and we don't want to blame somebody for how they respond. But there also are resources out there. And I think the resources are becoming more common knowledge. And so if you're really not sure too, you can call the distress center or different crisis lines, and they would have information on kind of where to go next too. So my piece.
Thanks, Quinn. Evan, did you want to add to that?
Sure. Yeah. So in terms of addressing harassment, if you've experienced it, there's two sort of dispute resolution mechanisms you might want to consider, both an internal and an external. So by law, under occupational health and safety legislation, employers are required to have a harassment prevention policy and procedures. So by law, they have to have a process for reporting complaints, investigating complaints, and then correcting issues that they may find. So the law requires that the employers make this process available to employees, that it's posted in at the worksite, either in paper or electronically. So one option for the employee, if they are experiencing harassment, is to make a complaint under that internal process. In addition to that, there's also an external process. If the employee is finding that the internal process isn't effective, then they can also file a complaint or issue a tip through occupational health and safety, the government department. And this is basically a government department that their mandate is to administer and enforce the health and safety legislation. And they have OH&S officers who can do an investigation, determine if there is harassment, if there's an unsafe work environment. And then they have various enforcement mechanisms that they can use in the event that they do find an unsafe work environment. So those are kind of two dispute resolution mechanisms that an employee could pursue. Those types of mechanisms don't offer compensation to the employee. So we kind of some of the other, legal complaints that could be filed, like a constructive dismissal or a human rights complaint, which those types of options would offer some sort of compensation for the misconduct by the employer. But it's always a good idea to speak with a professional, particularly if you're thinking of making a constructive dismissal claim, because in those circumstances, the onus would be on the employee to be able to substantiate that there has been that, what's called a toxic or poisoned workplace environment. So it's important to talk to a professional. And I think Quinn's advice about making sure to document instances of harassment and what's going on is really solid advice. So those would be my thoughts and kind of recommendations in a situation like that.
Excellent. Thanks, Evan. Andrew, did you have anything to add? And if I may prompt you, if there's any sort of limitations on responding to harassment in different ways?
Yes, thank you for that prompt. Yeah, I mean, generally that those are the options, how to deal with harassment at work. One thing you have to keep in mind is if just to report something to OH&S or to your manager, there's no you can do that at any time, no matter when the harassment happened. But if you actually want to take further steps, including, like Evan said, a human rights complaint or a constructive dismissal claim, those are extremely time-sensitive things. Very, very, for constructive dismissal, there's lots of cases which say, if the employee doesn't take action within a month or two, their claims can be barred just on that basis alone, even if there's no official limitation period, which in Alberta, from the date you knew or ought to have known that you would have a claim. So, I mean, lots of employees are just out of luck. They may think they're constructively dismissed. They may, essentially resign and sue, and eventually they're found that they just don't meet the test. So it's a good idea to talk to a lawyer, absolutely, about these things, and sooner rather than later, and absolutely with lots of written evidence. That's all very, very important. But the only thing I would add is I liked what Quinn said at the beginning about, there's no right way to respond to these situations, because it's one thing for as us lawyers to give you your official legal options, but it is really another thing to apply those practically in your everyday life and situation. And there's lots of people that we end up talking to, and I'm sure Evan has lots of these sorts of situations as well, where, technically maybe it is a constructive dismissal or a human rights complaint, but for that person's mental health and well-being, it's probably better that they don't pursue that route. So that's another reason why you should, again, talk to somebody about what you're experiencing, talk to a lawyer if you have concerns, and get that advice before you take any real formal steps.
Perfect. Thank you all for that. And hopefully if anyone's listening and is experiencing, hopefully that gives you an idea of kind of what your options are and some things to think about. Let's now switch a little bit and talk about what can someone do if they have witnessed a harassment at work. So maybe you're not the one who's experiencing it, but you're seeing someone else, like, maybe it's a colleague harassing another colleague. What can you do about that? And I will start with Quinn.
Yeah, great. So we call this being an ally, is how we refer to it. So harassment makes people feel very alone and lonely. And by being a good ally, you're showing them that they are not alone. So there's a few different things that you can do, and there's a few different things that I would discourage you from doing. So most importantly, you want to listen and support the person. Believe what they're saying. Do not question if they're telling the truth, and do not press for more details. The other thing to add is when somebody I care about experiences something that is painful for them, it can be easy to overreact. But we know that harassment comes often from a place of power and control. And so when we overreact, we feel like they have to then take care of us. And it takes away some more of their power. I also don't recommend that somebody report on behalf of somebody else, because again, that's further removing power and control from that person. Of course, the exception there is if somebody is in danger. You can also speak up and intervene. So you can confront the person, but again, that's not always safe to do so, and not everybody is okay with confrontation. A good way to intervene is to intervene by distraction. So if you see somebody being harassed, you can go up to either person in that scenario and say, hey, can you help me find this? Can you show me where this is? And in that scenario, you're removing the person from their harassment in a way where you're not directly confronting the person. I also think a good way, if you're witnessing harassment or you hear about it happening in other places, is to get with the issue, learn about what it looks like. Like we spoke about earlier, it's not always obvious. So to really engage with the issue, learn about resources that are available to people, so that if you have witnessed it, you know what resources to offer them and to let them make their decision.
Perfect. Thanks, Quinn, for that. Andrew, something to add to that?
Not much to add to that one. I would say that if you do witness something and you talk to the employee and they are okay with you reporting it, it's always good to report these things in writing rather than just verbally, because then, similar to our last question, you have a paper trail. There's evidence that you can point to. In April of last year, I mentioned this to you, and it's June and nothing's changed. So whereas if you just go and stick your head into your manager's office and say, hey, this happens, it may never be included or written down in an employee file or anywhere. And when it comes, if something comes of it, if a human rights complaint is issued or anything, it's very difficult to prove. So if the person is okay with you supporting them in that way, then certainly a written report is recommended.
Excellent. Thanks, Andrew. Evan?
I guess the only thing I would add is if the individual is okay with you supporting and bringing the issue to the employer's attention, it's important to note for both the people who are subject to the harassment that the employer can't take any sort of reprisal or retaliation action against the employee for asserting their right to have a safe and healthy workplace. So if an employer, let's say an employee reports an issue and then shortly thereafter they're terminated or disciplined, and they believe there may be a connection between the two events, they can file a complaint with occupational health and safety. An officer can investigate. And if that officer determines that, yes, there was a connection, then they have the authority to reinstate that employee's employment. So, employees do have some protection, and they should be comfortable to some degree raising these issues if they feel it's warranted to do so.
I think that retaliation piece, Evan, is really important too. And I believe there's also a provision under the Alberta Human Rights Act for the same thing. So if you are part of a human rights complaint for someone, so say you're, providing some sort of statement on behalf of the person who was experiencing harassment, there's also some protection from retaliation there as well. So for witnesses to know that retaliation is not okay and they're protected as well in some different situations. Well, thank you all for that. I hope that was, I think that was some great practical tips, and also some legal tips for supporting those who have experienced harassment and if you've been the one to witness it. So our next question should come as no surprise. We've talked again those experiencing, those witnessing, and now coming back to employers. So what can and should employers do about harassment at work? And I'm going to hand it over to Evan to start us off with this one.
Okay, yeah. So again, there are certain things that an employer must do by law. One of the big things is that the employer must have a policy related harassment, and they must have processes and procedures related to harassment. So the policy is really the overall statement that harassment won't be tolerated in the workplace. And then the procedures and the process are what sort of implement that policy on the day-to-day basis. And that has to include things like a process for reporting harassment, for investigating, also for informing the parties to the complaint about what the outcome was and whether there's been any corrective action. So those are important responsibilities that the employer has. The legislation doesn't talk about specifically, what the investigation would look like or how extensive it needs to be. But my recommendation would be, if there's an incident of harassment reported, I would at least interview the witnesses who witnessed it, as well as give the subject of the complaint an opportunity to respond before taking any sort of corrective action. That would be my recommendation on a best practice. In addition to that, the legislation does say that, in the event that someone reports harassment, the employer has to advise the employee that they can seek mental health support. So that's another important obligation that employers would have to follow. So those are kind of the key things that, legally speaking, an employer would be expected to do in the event that a harassment complaint was brought to their attention.
Thanks, Evan. Andrew, did you want to add to that?
Sure, yeah. Sometimes there are situations where employees face harassment from, outside actors, members of the public. This can happen in a variety of workplaces like retail, or, if you're talking about the public sector, public administration. And in those situations, obviously an employer should investigate any reports and take all those steps that Evan mentioned. But sometimes it's a lot more difficult to deal with harassment from somebody who is not an employee under your control. And in those situations, employers have to get a little creative in how they deal with these situations, because receiving harassment, even from an outside person, is still, if it creates an unsafe workplace, that's still potentially a violation of their occupational health and safety or obligations. So obviously policies, as Evan mentioned, are very, very important. But, in other cases, other legal steps can be taken. So if we're talking about, for example, a retail store, if you have one customer who's constantly coming in and harassing your staff, you as an employer are entitled to issue a trespass notice, which would prevent those people from coming into your store. And if they do, they can be arrested. Similarly, there are situations where a person is threatening multiple people who work at a particular business. If that person is threatening violence or just general unwelcome repeated harassment or following, you technically can obtain a restraining order, which should prevent that kind of conduct. So there's lots of these sort of other steps that employers can take, usually through a lawyer, but there are other steps than just sort of that may be required where the person doing the harassment is outside of the employer's control.
Excellent. Thank you. Thank you for covering that for both of you, that both internal and external, the person committing the harassment being both internal and external to the organization. Quinn, did you want to add to that?
Yeah, I just have two quick things to add. So firstly, and this is quite frank, but take it seriously. If someone reports or complains about it, that sounds obvious, but unfortunately it's not. To a lot of employers. My other piece would is to be proactive. So if you're an employer and you think, there's no harassment happening and I don't really know what I'm going to do about it, I'm going to wait till it happens. That's not always the best option. You can be proactive. There is training out there. There is lots of literature. There's resources that you can reach out to. Be proactive in the sense of not only learning what to do if it happens, but also steps you can take to actively discourage it from happening. We know that safe and respectful workplaces discourage harassment. So rather than just sitting around and kind of waiting for it to happen, learn about what to do if it happens, but also what you can do to prevent it from happening. I think we talk a lot about, how to react to it, but prevention is a big deal. And if employers take it seriously and take prevention methods seriously, then they might not ever have to worry about what to do if it happens. So that's just my piece.
Excellent. Thank you. Thank you for that. And I agree, prevention is very important. And on the policy side, then, creating a policy can be a form of prevention as well. But you follow the policy. So policy is not just a piece of paper. If there's a process in it, then make sure as an employer too, that you are actually following through with that policy and giving it some substance. So that's what I would add to that as well. Thank you all for that great discussion. We've come now to our last question, and I think this is really meant to wrap us up here. We've talked extensively about different resources available and different options. And so we want to take a few minutes and go through some of those different options, and some maybe obvious resources, but some maybe not so obvious resources, both on the prevention and responding to side. So we're going to have a few slides here and go through some different options, and then I'll hand it over to Evan and Andrew as well to fill in any blanks. But we've talked extensively about the human rights issues. So again, I just want to reiterate, the Alberta Human Rights Commission is a resource. They have information on their website, not only about responding to it if you are the employee, but also if you're the employer, and then also some education tips as well for that prevention piece like Quinn talked about. So again, they administer the Alberta Human Rights Act. They deal with human rights complaints, so they can accept complaints from employees who've experienced harassment at work, again, that's related to a protected ground, which are defined in the Act. And they also do education on human rights and discrimination generally. So and their website has lots of great information there. Okay, I'm going to turn over to Quinn. As promised, we were going to talk more about the Workers Resource Center. So here we are.
Sorry, I was having issues with unmute. Okay, so this is me. So I work at the Workers Resource Center. So we are located in Calgary, but we serve anybody in Alberta. So the program that I advisory program. So I work with people who have experienced sexual harassment in the workplace. I let them know what their options are, give them information, supported referrals. If they choose to go ahead with an Alberta human rights complaint, I assist them with the paperwork, and then I become their authorized representative. So I become kind of the middle person between them and the Alberta Human Rights Commission. And I follow the complaint all the way through to wherever it concludes, whether that be at conciliation or tribunal or somewhere else. My colleagues, so I'll say, so under one protected ground under the Alberta Human Rights Commission is gender. So sexual harassment falls under gender. But my colleagues at the Workers Resource Center assist in filing human rights complaints for all other types of discrimination for different protected grounds. And we don't just do human rights for Alberta, we can also do Canada, Canada human rights for federally regulated industries. We also assist people in getting EI if they go on medical or if they're terminated, which unfortunately happens, employment standards, if they're owed pay. So we exist to help workers in Alberta, and we are free. So that's the best part. Oh, this is me again. Sorry, I'm sleeping over here. Okay, so Moments Matter is run through ASAP. So as Jessica mentioned at the beginning, there's a group of us that were funded. I think she mentioned this, but if not, I'll mention it now. There's a group of agencies that were funded by the Federal Department of Justice to offer resources to people who have experienced sexual harassment, information about it, training, etc. We have come together and created a website where all of this information is linked. It's not launched yet. It's coming out in June. It's going to be all over our socials. We're really going to push it out. So stay tuned for that. But until then, this will have to do. So the Association of Alberta Sexual Assault Services has a campaign that they're running called Moments Matter. So they share stories and information and kind of what I was talking about earlier, a lot of the preventative work. So how to make your workplace safe and respectful, as we know that discourages harassment. They also offer a really great training. So it's called Engagement Strategies Towards Ending Workplace Sexual Harassment. I'm not even biased because these are my friends, but it's actually so good. You know, you go to those trainings at work and it's like a snooze fest and it's like not good at all. This is really it's so good. They put so much work into it, so much research. It's very engaging. I just can't say enough good things about it. So I would encourage you to take it. If you're someone on the leadership team, someone, get your workplace to take it. It talks a lot about how to identify sexual harassment, how to address it, and that kind of thing. So that's that. So the Alberta Civil Liberties Research Center, so they do a lot of research around civil liberties and harassment. They, on their website, have a lot of good videos on sexual harassment. They also do like in-school classroom training. They're another great resource out there. My French is poor, really poor, so I'm not going to say the name of this of this agency. I just call it a JEFA, but they offer services and information. They're based out of Edmonton, but they're really great. You can go to their website there if you're looking for French information and legal information and resources. They also connect to other French agencies provincially as well.
My French is also poor, but for translation purposes, I can say that this is the Alberta Association of French-speaking lawyers. And so they work to do a lot of work, as Quinn said, around spreading French legal information. So another great resource there. And I think we missed one because Evan and Andrew have both talked a lot about this, and I didn't put a slide together, and that would be OHS. So Evan, I don't know if, or Evan or Andrew, if you want to elaborate more, I'll start with Andrew maybe on that and any other resources that are available to employees and employers.
Yeah, well, I mean, Evan did a great job throughout this presentation talking about all the reporting mechanisms for OH&S. So obviously, if you're concerned, start with the OH&S website. They have a phone number, they've got online, I'm sure they have an online submission option. I'm not 100% sure about that, but and other government agencies and websites like Employment Standards is also a good place to start to look up, some of the basic rules about workplace rules and laws. But when it comes down to it, if you don't really find your answer for your specific situation, at the end of the day, it is a good idea to talk to an employment lawyer. There was one of the questions in the Q&A is about a situation where the person doesn't think they can afford a lawyer, and there are some good resources there. For example, the Edmonton Community Legal Center, you can call them in advance. They will schedule you an appointment to consult essentially with a lawyer, and that's free of charge. That can be very helpful. There's also the Law Society of Alberta has a lawyer referral line where you call the Law Society and tell them what your issue is, and they will give you a list of 3 lawyers on their lawyer referral line list. And those lawyers are obligated to provide you with a free 30-minute consultation on your situation. So, there are resources out there for someone who doesn't think they can or they may not want to right off the bat incur those expenses.
Perfect, thank you. Evan, any other resources or tips for employees or employers?
Well, I guess the only other big one that I would probably recommend is Pro Bono Law Alberta. I know they have a civil duty counsel service available at the courthouse. I believe it's on the 15th floor, which I've participated in and I think is a really great program. But basically they can provide 30 minutes of free legal advice, and as well if you need help drafting court documents or complaint forms, they have lawyers available that can do that. So I think that's a great one. In terms of the question about affordability, I think that's an important question. One of the things that people can consider too is that some employment law firms will take matters on a contingency basis. So basically what that means is the client doesn't pay legal fees up front, but what happens is if the lawyer is successful in getting a settlement or a judgment, they're paid a percentage of whatever the settlement or judgment is. And I find that could be a way to sort of help give access to justice to people who might not otherwise be able to afford it. So that's something that, individuals can consider as well.
Perfect. Okay, so there's a lot of great resources mentioned, and I think I'll just kind of summarize quickly. So the Workers Resource Center, as Quinn mentioned, that's where she works, can support Alberta workers with lots of different claims before different government bodies or related bodies, administrative bodies. And of course, then there's also going to a lawyer, as we've talked about, and you can access those in different ways, whether it's through the lawyer referral service, Google, and other ways that you could find a lawyer. And then pro bono options are free options. As Andrew mentioned, the ECLC here in Edmonton is a free legal clinic. There are legal clinics across Alberta that offer the same type of services. So there is likely one in your area: Edmonton, Calgary for sure, Grand Prairie, Fort McMurray, Lethbridge, Medicine Hat, Red Deer, and I might be forgetting one, but the province is well covered with clinics as well. So you may be able to access some free advice there. And pro bono, and I just want to clarify, pro bono operates the Civil Claims Duty Council, which Evan mentioned. That is in the Calgary and Edmonton courthouses. It's in person only, so you actually have to go down to the courthouse and queue up to get an appointment, but a great resource as well. So, and then as we talked about, the Alberta Human Rights Commission, occupational health and safety, and then some of the agencies doing specialized work in this area. So definitely lots of information and resources available. We have covered a lot today, I feel like, and we have still 10 minutes, and I see there's some questions in the Q&A. So I'd like to get to some of those if we can. So maybe head over there, and if any of our panelists want to take one of the questions, then they can do so. So someone's writing about their wife facing harassment at work, and when they were trying to do something about it, they were fired. So the big issue of not knowing the process to follow to make a complaint about it, and also then as we already talked about, the expense of hiring a lawyer. So does one of our panelists want to address that further?
I can start if you'd like. So it's difficult to comment on someone's personal situation in a environment like this. So I will speak very generally. If it happened within 1 year, you can file an Alberta human rights complaint or Canada human rights, but it needs to have happened within the 1 year. My services are free when it comes to just with the part of the question there, the fees that come with a lawyer. So I would need more information before I could say if I could assist you or not, but I would just recommend you can call me. I think our number is probably in the chat, and I can let you know. So I can't help with any sort of civil action that you choose to take, but I can have a conversation about human rights and whether or not that qualifies for you. So just from that piece, I would feel free to give me a call and we can talk more in depth.
Thanks, Quinn.
I guess what I would add is, so if it's a situation where an employee's been terminated, ideally the best thing to do would be to speak with an employment lawyer about the situation, even if it's just for a 30-minute consult or an hour consult, because the lawyer can kind of give you whether there's a viable claim, the options available to you, which may include, trying to negotiate a settlement or, if necessary, pursuing a claim. But they can kind of give you an idea of, if you pursue a particular option, what the outcome might look like. And typically, if you've been dismissed, you're looking at a potential wrongful dismissal lawsuit and potential damages for lack of reasonable notice, and then there may be some additional claims related to harassment or human rights discrimination. So it's always a good idea to speak to a lawyer if you can, and then they can kind of give you the options available so that you can make an informed decision on it.
Okay. There's a follow-up question about a union being involved, and as well, how long does it take to get resolution? And I can maybe take that one really quick to say, how long does it take to get resolution? And this is everyone's favorite answer from a lawyer, but it really depends on the process that's being engaged. So I think my co-panelists would would agree on that it really depends on what the process is, and you know, sometimes it can take years, sometimes it can be resolved quickly. So on the union side, did anyone want to respond to that one?
Sure, I can respond to that. Yeah, I mean, again, it depends on the situation, but generally, when an employee is represented by a union, they really have limited options as to what they can do with an outside lawyer. The first step is always to talk to your union rep, you know, and it's called submitting a grievance through that process. So if you believe you've been bullied, talk to your union rep, say, look, I want to submit a grievance, and then it's up to the union to basically decide what they want to do. So then in answer to the question, you know, if you've got a union, but they don't want to help and they're just ignoring you, there is a process for that through the labor board, and it's called a duty of fair representation complaint. And so in certain situations where a union doesn't uphold their obligations of representing an employee, and that would include submitting a complaint for harassment where one is warranted. The employee can't just go and submit a human rights complaint. You can't do that, but you can submit a complaint to the labor board, and the labor board will then look at what the union did in the situation and basically decide if they acted fairly or if not. And the employee can get remedies directly as against the union in that situation. So, but again, just like Evan mentioned, it is the kind of thing where you should probably talk to a lawyer about to get a consult, because you don't really want to be submitting those kinds of complaints just on the off chance that, you know, maybe it'll be successful, because it is a formal hearing process and there's a lot involved at the end of the day. So.
Perfect, thank you. There's a question here about, as an ally, what should I do when a colleague tells me she's facing harassment but does not want to report it? And I think we covered that a little bit, but did anyone want to expand on that situation?
I would just say, you know, that's a tough position to be in, but I would just say, listen to them, support them. You can let them know what their options are. You know, you can say, if you choose to report it, I can come with you. So give them options. Don't, tell them what they have to do, but just be there to listen and support is the most important thing.
Perfect. There are some questions here about reaching out to our presenters and sending out resources in an email. So when I send out the email about the recording being up, I can include some of those different resources that we have mentioned, including pro bono. So I can reiterate for that one specifically, that one's called Civil Claims Duty Council. So if you Google that, it's run by Pro Bono Law Alberta, or PBLA. And like we mentioned, it's only in Edmonton and Calgary at the courthouse in person right now, but they can provide some different services there. I think you get 30 minutes for free with a lawyer. So that one's there. But we can look at kind of putting together a list as well when we send out further information. I think that's all of the questions, unless our panelists have anything else they would like to add.
I guess I just wanted to say thanks for including us. I think this is an important topic to talk about, so I'm happy to have participated.
Excellent. Well, thank you to all of you, Quinn, Evan, and Andrew, for your great perspectives on this and for sharing. And I hope all of you watching, if we learned something new and are taking something away from this. So I do want to say a huge thank you to all of you for joining us and spending your lunch hour with us. And also to all of you who have tuned in. Again, thanks for joining. And I do have a few more slides. I better not forget that. Otherwise, I'll be disappointed I didn't get to the rest. So again, as I mentioned, CPLEA, the work that we do is providing legal information and education. So again, cplea.ca, you can find a bunch of free legal information, including resources about what to do next on our website. And you'll see there's there, and that's what information. And then this is our second webinar in a series we're doing this spring. So we did a couple weeks ago, we did owning property with someone else, which will be available on our YouTube channel shortly. Coming up though, we have one on dying without a will. So what to do in that situation, maternity and parental leave. So again, coming back to the employment topics, that's at the beginning of June, getting a grant of probate when someone has passed away. And we'll finish up with another employment topic on privacy issues at work. So if you haven't already registered for those, please head to cplea.ca/workshops, and you'll find the registration links there, so you can join us every 2 weeks for the next 6 weeks. We hope to see you there. And with that, I'll wrap up and just say thank you very much for joining. And once again, when you leave today, you'll be prompted to complete a short survey, and we would really appreciate if you could take 30 minutes just to fill that out. But other than that, thanks so much for joining, and have a great rest of your day.